And so our book gives us some common forms of business entities. It talks about the sole proprietorship that we're going to talk about in chapter 13, the partnerships, general and limited partnerships, general partnerships and limited partnerships, limited liability partnerships, and the limited liability company. In chapter 15, we're going to talk about corporations, okay? And then these are some considerations that your book talks about when setting up or choosing one of those business entities. You want to think about formation, liability, your capitalization, taxation, management, and operation. But for me today, what I really want to talk about with you all today is liability. Because that's the one right there that is really the one that causes most problems for a business. And so I want to talk a little bit about sole proprietorship. This is just like a business of just, just one person owning the business. And in this particular type of business, it's just, just a simple business. You use your own money to capitalize the business, your own credit card or whatever. You may even take out a personal loan or whatever. But this is not the type of business where there are more than, it's really just going to be one person who's running this business. Sometimes, I was going to say maybe like a solo practitioner law firm might do this. I've done this in the past, but you really want to protect yourself from liability. So we'll see some other types of business entity. If you have to do this, this is just going to be like for it's going to be a very small business you want to do this with. I mean, even like if it's a food truck or something like that, you really want to make sure that you are protecting yourself from liability, because these days people will sue you for anything. So then there are partnerships, okay? And then our text tells us this is the simplest type of a multi-person business entity. And then there are two types. You have your general partnerships and your limited partnerships. These are some features of our general partnership. It's fundamentally a general partnership is an association of two or more people or entities who are co-owners / co-managers and share in the profits of a business. However, general partners have no protection of their personal assets from unpaid debts, liabilities of the partnership, and may be held jointly and severally liable. Your book talks about this term, jointly and severally liable. That means if there is a judgment against the general partnership, then if I have a $100,000 judgment against the general partnership and I have two partners here, if I find that she has $100,000 in her bank account, I'll just take it all out of her bank account and I can be done with it. Because they are jointly and severally liable. I don't have to get 50 from her or 50 from her. I can get it all from one, some from the other. They're jointly and severally liable. And they also, general partners, have the power to bind the partnership to a contractual obligation. And this is also going to go to liability. So when the time comes and somebody wants to point the finger at who, they all have the obligation to bind. And then our limited partnerships. So right now we're talking about partnerships, general partnerships, limited partnerships. We talked about our sole proprietorship. And the sole proprietorship definitely has no protection from personal liability either. General partnership, we have our partnerships, two types. General partnership. General partners, no protection from personal liability. Then we have our limited partnership. Sometimes that general, you have an entity and you may have a person who, or an entity that just wants to be an investor. in that company. They're not necessarily involved in the day-to-day. Well, the general partners in that particular aspect are going to have no protection from personal liability. However, these limited partners, they're going to have some type of a protection from personal liability. Since each general partner in a limited partnership is personally liable for all of the partnership's debts and liabilities, while the limited partners do not have the same automatic personal liability. And then limited partners, they do not participate in the day-to-day operation. These are just people who are like just investors of a company, or is an example of that. And to form a limited partnership, you will see that most times you'll see that somebody will have to file a certificate of limited partnership with the Secretary of State. So now we're going to talk about limited liability companies and limited liability partnerships. And our book tells us that prior to the development of LLCs and LLPs, principals who wish to avoid double taxation of corporation but desired liability protection for their personal assets had few choices, but now they do. The LLC and the LLP are examples of that, and they are similar in some ways to the entity that we'll talk about in our next class, which is corporation, which is the type of entity that provides protection from liability. So let's look first at the LLPs. And then it goes back and it kind of reminds us of the general partnership situation where it says the danger of being a general partner is the potentiality of liability for acts of the other general partners, debts, and liabilities of the partnership itself. But LLP statutes, and this is going to be how this, is authorized, normally by some type of a state statute. LLP statutes provide partnerships with a protective shield ordinarily afforded to limited partners. You remember, limited partners in the limited partnership type of entity, the general partners don't have protection, but the limited partners who are investors do. And this is similar to that. Limited liability partnerships are formed when members file a statement of qualification with the appropriate public official or state office that is always probably going to be the Secretary of State. That's where these documents will be filed. If you ever want to find out the status of a business, whether it's a limited partnership, a limited liability partnership, a limited liability company, you will go to the Secretary of State website, or if they don't have a website, you can contact the Secretary of State and find out when that business was established or if they are registered with the Secretary of State. And then this talks about our liability. The general idea behind being a LLP is that all partners in a limited liability partnership will have protection for personal debts and liabilities of the partnership. But some states impose conditions on these limits. So it is not a all-in-all guarantee, but in general, this is the point of establishing a limited liability partnership to protect oneself from personal liability. In cases where a partner has engaged in misconduct or tortious conduct, such as negligence, which is our favorite one, the LLP acts to shield the personal issues, say personal assets of other partners. And it says not the partner who committed the misconduct or the negligence. This will depend on some things, though. And then it talks about the management and operation of the limited liability partnership. The day-to-day operation and powers of the partners spelled out in the partnership agreement. And then there'll be some other things that are also spelled out in that partnership agreement. And then our book talks about the limited liability company. And it is characterized as an entity whose primary characteristics of that, it offers its principals the same amount of liability protection according to principles of a corporate form of entity or a corporation. An LLC is formed by filing articles of organization with the Secretary of State. An important feature of an LLC is the limited liability of its members. And the LLC members are insulated from personal liability for any business debts or liabilities, contract or tort, if the venture fails. So we're going to start here and see. Let me get set up first before I give you a question. Which of the following does not enjoy protection for personal debts and liabilities? Which of the following does not enjoy protection for personal debts and liabilities? Which of the following, and then some people are going to try to change their answers. It's too late. Which of the following does not enjoy protection? It's B, general partner. And then our slide, remember our slide tells us that general partners have no protection of their personal assets for unpaid debts and liabilities of the partnership, and may be held jointly and severally liable. Okay. And then there's some other stops that we want to make here. Our book talks about the member managed LLC and the manager managed LLC. This is self-explanatory. The management structure of the entity is similar to that of a general partnership, with all the members having authority to bind the business in the member management. Now, in a manager managed LLC, they're going to name one person who's going to be responsible for the day-to-day. And that's your manager managed LLC. And that person should be careful, because when the time comes to determine what the problem is, that person is going to be the person that's going to be looked at. And so a court may discard the protection. See, I got rid of that one that you had. I'm fine with it, but this is the one that I'm really more concerned about. A court may discard the protection in a case where the court finds that fairness demands that the LLC member should compensate any damaged party when the entity is without resources to cover the full amount owed. And see, that is really going to be the problem. See, if you go and sue Walmart, that's going to be the deep pocket. But if you have a company and they don't have any money, they're insolvent, you're going to have to find a way to go after that personal liability of the person, the member who may be a member of that. And that's where most of these fights come in, because that is what people are doing. they'll set the business up, and they'll, whatever money's in the business, they'll take it and hide it in their personal account, and then let the business absorb all of the liabilities. If somebody sues it, and they'll say, oh, ha, 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 we don't have any money. And so then that's where the problem comes in. So we're going to look at something like this in our example today in Monica Allen versus J. Dackman. Look at this case. And this is in an unfortunate little set of facts here. I'm going to go down. Okay, wait a minute. You're not going to be able to see that. Can you see that? Mm-hmm. I really want to know if you can see it. Can you see it?
Yeah.
If you, okay. If you can see it, then everybody else can see it. You're my tester. I'm going to blow it up just a little bit. Is that better? Okay. We'll go down to the facts. This is what a case looks like when I go to Westlaw and I put in whatever, looking for a case. This is what it looks like when I get it back. So I found this case, and what I did was I went into my Westlaw and I put this number, because remember I told you about cases, every case has its own fingerprint. So if I go to this book in the Atlantic Second, the first page of this case is going to be 1216. No other case has that number. And this is taking us to Maryland. Let me go back here. Okay. So this is what happened here. Miss Allen, or Monica Allen, was born on September 8, 1996, and then her sister, Shantice Thomas, was born on January 20, 1998. Sometime in 1999, is calling this the petitioners, which is their mother, moved into the property in question where the children's grandmother, Tracy Allen, lived. Okay, Miss Allen leased this property from Mildred Tompkins, who was the owner at that time. But sometimes you have a problem with property where, a person may not pay the property taxes. If you don't pay your property taxes, whoever you owe those taxes to can foreclose on your property. So be careful about that. And because there are people who are just sitting around waiting to buy foreclosed properties from people who fail to pay their taxes. And so this is like property that you're going to get at a windfall. I mean, because you're not going to be paying the full fair market value of the property. You got it at a tax sale. So this is a good business for some people, because they go and they get a house at an auction for nearly nothing. And then they just flip it and resell it. Well, that is the business that Hard Assets, which is a limited liability company, this is the business that they were in. Okay, so Ms. Tompkins failed to pay her taxes on the property. And on March 16, 2000, Hard Assets acquired the property from her in lieu of foreclosure. When it says respondent, they're talking about Mr. Dackman. Mr. Dackman I found is an attorney, but Mr. Dackman, when it says respondent, that's who they're talking about, Mr. Dackman. Okay, it says Mr. Dackman was one of the two members of the limited liability company, Hard Assets. Okay? Over the course of Mr. Dackman's 15 years in purchasing tax liens, it was his practice to sell the properties he acquired as is. I mean, he never even went to the property to assess whatever kind of shape it was in some instances, rather than keeping them as a rental property. So he didn't keep these, he had no intent on renting them or anything like that. He would just flip it, get it for nothing, and sell it. That's how you make money, okay? So when Hard Assets obtained title, it did not intend to lease the property, nor were its members aware that petitioners or Miss Allen were living on the property. Once Hard Assets became aware, however, that they were there, Hard Assets advised them that they were not supposed to be there. Now, what he should have done was he should have evicted them. But that costs money. When you are buying a property in this way, I mean, you don't want to spend a lot of money because your intent is to flip it. So he just says to them, you're not supposed to be here, hoping, I guess, that they will leave. But he's come to Los Angeles because you can tell somebody to leave and they'll never leave. You have to evict the person to make sure that you're in your proper legal standing. And so he didn't do that. But after 30 days, petitioners and Ms. Allen had not vacated the property. On June 27, 2000, Hard Assets filed a forcible entry and wrongful detainer complaint. In other words, an eviction. That's what they did. Okay. And against Ms. Allen in the district court for Baltimore City to have her and the petitioners removed from the property. And so respondent, or Mr. Dackman, signed that complaint on behalf of the limited liability company. On August 18, 2000, judgment was entered in Hard Assets' favor when the district court found that Ms. Allen was wrongfully in possession of the property. Okay, she's wrongfully in possession of the property because the property is now owned by Hard Assets. Okay, Ms. Tompkins didn't pay her taxes, and so the property was really foreclosed upon. They're saying in lieu of foreclosure, he obtained the property, but Ms. Tompkins is no longer in possession of the property, so she no longer has the authority to lease it to Ms. Allen. So Ms. Allen is there unlawfully. Okay? I'm sorry. Oh my God, if you're sad about this, then wait till I tell you what happened. Oh my gosh. Okay, so I almost hate to tell this story now. Okay, so Hard Assets sold the property on March 16, 2001. Hard Assets sold the property on March 16, 2001. During the 1-year period that it held title to the property, Hard Assets did not receive rent, nor did it file collections for rent. In the eviction, it looks like they didn't even ask for the past rent. So, likewise, Ms. Allen did not pay any rent to Hard Assets. She was living there for free.
I know, it's like that.
Okay? Ms. Allen did not speak to Hard Assets or its representatives. Okay? So neither one knew the other, in essence, and was not aware of who Hard Assets was. So I guess Ms. Tompkins never told her. I guess. Similarly, Monica D. Allen did not know Hard Assets are the respondents. Okay, so from March 16, 2000 to March 16, 2001, when it sold, Mr. Dackman was responsible for running the day-to-day business affairs of Hard Assets. So see, so what would we call this kind of limited liability company? Anybody? What type would we call this?
LLC.
Okay, but what type?
Oh, you mean like general or?
From the operation standpoint.
Oh, manage.
Which kind? Which one?
The other one, not the managed one, the other one.
Not the, they're all
It's
managed.
Never mind.
Which one though? Remember I was telling you how to be
Yeah.
careful? See, I have to keep y'all involved because I'll tell you something you'll forget real quick. Because you're doing your Learn Smart during class. There were two types that I talked about. Limited liability companies from the operations standpoint that I talked
So we have the membered managed LLC.
Okay.
And the manager managed LLC.
Okay, what would you call this?
It's not really managed, I mean, it's not even there.
Well, but hold on, what are you saying? Listen, look at what this says. It says he was responsible for running the day-to-day business affairs.
Yeah.
Okay, so what will we
So
call
we go
it?
with the manager managed LLC.
Because what did they do? What did it look like Hard Assets did? That they kind of designated a manager to handle the day-to-day. Isn't that what this looks more like?
Yeah.
And so the majority of the business involved the as-is sale of property, several purchased and acquired through tax liens. This is what they did. This is what the whole purpose of the business was. Okay? And so Mr. Dackman never set foot inside of the property. He was just going to sell it. Never even looking at it. He wasn't even going to send anybody over there to look at it. So... Okay, so while residing at the property, each of the minor children suffer from elevated blood lead levels. I know you don't like that. Some of their elevated levels occurred before Hard Assets acquired the property. However, some occurred after Hard Assets sold the property. Okay, both minor children suffered from their highest blood lead levels, while Hard Assets held legal title to the property. As a result, petitioners filed a complaint against Hard Assets and Mr. Dackman on June 11, 2002. Okay, Mr. Dackman, being an attorney, he already knows that he's going to file a motion for summary judgment because he believes that he cannot be sued personally, maybe Hard Assets, but not him personally. And so on June 20th, 2005, Mr. Dackman filed a motion for summary judgment asserting that he could not be held individually liable for these reasons because he did not lease the property. They were living there for free.
Right, there's no more.
Okay. And that because he was a member of Hard Assets, a limited liability company. See, that's the whole point of doing the limited liability company. And 3, he had no knowledge of the alleged tort, and he could not be held liable under the CPA, which is a statute that governs corporate entities in the particular state. So I'm not so much concerned about that. But the fact of the matter is, he never set foot on the property. He didn't know that there was lead there.
Or is this not basically like Miss Tompkins' fault? Like they should
Okay.
back her.
Now, would you sue Miss Tompkins? She can't even pay her taxes.
That's true, but there has to be some kind of money. You said, right? You have to.
Some
where
money?
That's
For
where
what?
someone finds it.
For who? For
Well,
Miss
because
Tompkins?
she wasn't even telling them about it.
Well, I'm just saying, but she didn't have any money to pay her taxes to keep her real property. So you think she got any money?
No.
So who you gonna go after? You gonna go after the deep pocket?
But the
Okay.
fact of the matter here, it said in the case that they had not done anything. It was literally an acquisition. Oh, wait. Did they flip the property? No. So did they change the property, or they just bought it and then
And sold it.
sold it? So nothing were done.
No.
That was already a pre-existing condition from the children's.
Oh, I love that legal word you use, pre-existing condition.
You use that important in the health context too many times as well, believe me.
Yes, that's a very legal term, but let's see what happens. Let's look at it. Okay, this is what the court is saying. Okay, so I can go through the procedural history of this. I can go back to the procedural history, but the fact of the matter is, the trial court believed that Mr. Dackman was right, because in general, when you file that motion for summary judgment, that's going to be granted, and so it was granted, and then the petitioners appealed, and the Court of Appeals agreed with the trial court that Mr. Dackman cannot be held personally liable. I mean, this is a LLC. That's the whole point. So now we're in the special Court of Appeals, and let's see what they say. And now I'm gonna go back to. Let me just take a minute and go back to a slide. A court may discard the protection in a case where the court finds that fairness demands that the LLC members should compensate any damages. I'm just going to go back to that, because I don't know if I agree with this opinion or not. But the Court of Appeals now, the Special Court of Appeals has this, and they say to decide this case, we must interpret the housing code. Now I'm just going to ask and see if somebody is going to be able to answer this. What source of law would that be? The housing code.
It's our regulations.
Say that again? I didn't hear you. What kind? Source of law. How many sources of law did we talk about? Now I talked to y'all about this. We had our apprentice, and I went back to the slide. I don't know how many times. Anyway, I'm gonna move on. So those are just furthermore facts that would probably be. I don't know what the resulting. What you have to do if there is, I don't know if what the law is here, if they're saying you can't have any lead paint or whatever the case may be, but the fact of the matter is we have people who were injured, and so all they have to do is establish that they are the class of people. What this is saying is that the housing code also sets a variety of requirements that owners and operators are obligated to meet in regards to dwellings. The requirement at issue in the present case was set forth in section 702 of the code, which stated that every building used or occupied as a dwelling be kept in good repair and safe condition and fit for human habitation. And so, at the end of the day, respondent argues that he could not have been an owner of the property because there is no evidence that he personally had ability to purchase and sell the property. The court said, no, we're not going for that, because you are the person who signed the deed, or who you were in charge of the day-to-day operations of the business, and you had the ability, if you wanted to sell the property, you had control over the property. So what he's saying is that it was hard assets property, not my personal property. I didn't have the ability, but the court is saying, no, you are the person who ran the day-to-day operation. And so my point here is to just let you know that this is not a all-in-all protection from personal liability. Okay, you have to be careful when we are choosing a type of business entity. Okay, so the first thing we want to do is make sure that we're choosing a type of business entity that's going to protect us from personal liability. But then we still have to be sure that we're not conducting business in a way that can bring liability onto the company. You still have to be thinking about the types of things. I mean, you just can't go buy a property. You know people are living over there. You probably, you need to take steps to protect the business and yourself from because you could be found to be personally liable if your actions are that egregious. Okay. So let me go back here. So I'm going to ask one question. I might ask two. Okay. Would you have advised Blackmore and Hard Assets to evict the family as soon as the property was acquired? These are business decisions, okay? Yes, it's harsh, Miss Natalie. It's harsh. But you have to make a good business decision for the business and for yourself because, as you can see, those people didn't pay one dime of rent to Mr. Blackmore. And guess what? He's going to be out a lot of money on a property that he bought so that he could flip it.
Mm-hmm. Yeah,
so you can't just go and buy a property, don't put eyes on the property. You know people are living over there. You better get them out of there. I mean, if you go back and look at the facts, even after he filed the eviction, the people still didn't leave. He had to go and file another action to actually have them removed from the property, and then they come back and they sue him.
And is it not something that is not an argument he could have had to demonstrate the court that he tried absolutely everything because he knew that was not safe?
Yes, he could have done that, but as you can see here, this court did not like what happened.
I know.
So they found a way. If you go and look at this case, there were different times where this court said, let me see if I can find it. I mean, they went out of their way to they said many times, we have never they said many times in this case, we have never determined the definition of this or that. This is the first time that they did so in this case, just because they were trying their best to make this right for this family because these children had lead poisoning. So they went several times throughout this case. You'll see where they said, we have never determined the definition of this or that. And they just did it just so that they could, in essence, fix this situation for this family. Let me see. We'll have one more question. So the moral is that when we're choosing a business entity, we need to be careful in our selection. I mean, you don't necessarily want to do a sole proprietorship or a general partnership. You want something that's going to provide some liability, some protection from personal liability. Oh, this is my question. Do you agree with the Court of Special Appeals decision to deny Mr. Blackmore protection from personal liability provided by his status as a member of Hard Assets, which is a limited liability company? It's 50-50. Okay. I don't know what to say about this. I mean, it's a harsh situation, but you got to be careful. If you're going to run a business, you can't just be, this guy is a slumlord, in essence. because you're going to let the people live in the house. And then he didn't even, I feel sorry for him. He didn't know that there was some type of lead paint or something in there that caused those children to have high levels of lead poisoning. So, are there any questions about this limited liability? This is come in any kind of way, breach of contract or anything. If your business is not going to protect you from personal liability, you want to rethink your choice of business entity and file the appropriate documents with the Secretary of State so that you can have a business entity that is going to be protecting you from personal liability, so you can keep your personal money. If somebody gets a judgment against you personally, they can, in California, for instance, they can garnish your bank account. They can garnish your wages. They can have the sheriff to come and pick up your vehicle. All kinds of things. The other day, I had the sheriff to break into somebody's Bank of America safe deposit box in Alameda County. There were 2 little rings in there, but we're going to see how much there were. So you want to be careful to protect yourself from personal liability. Okay, so let's just make sure that we will. Any questions about this? Yes, ma'am.
I was reading somewhere and I forgot the answer, but I was surprised to learn what the most popular type of business was. It wasn't what I thought it would be.
What was it? You don't remember?
I'll find it, but it wasn't. I mean, I think it was the sole proprietor.
Well, it is. And that's what our book will tell us, because you don't have to file anything with anybody. People are not thinking about these kinds of things. I mean, you don't have to file any type of special tax pay. I mean, I could just do my same 1040, and I can do, put that Schedule C on there and just file that with my just normal taxes. I mean, it's just easy to do.
Yeah.
That's why.
Okay.
But you can get sued.
Yeah.
So like, even for me, I used to do that with my law firm, but then eventually I had to go ahead and do a LLC. Okay.
Before or after damage?
Well, no, nobody. I just want to make sure that I don't get sued, because when you start bringing on clients and that type of thing, people, they get upset about things. They'll sue you for anything. Somebody could come into your law office and slip down. So you want to be smart about what kind of, but yeah, it's easy just to have a sole proprietorship, yeah. And that's why people do it, because it's so easy. But you'll just file just one little, every state has a Secretary of State's office that makes it very easy for you to just file your articles of incorporation, incorporate the business, and then you'll be completely protected from personal liability.
Because then it's its own,
Yeah.
Yes. Then it's its own thing. If anybody wants to sue for anything resulting from the business, they're going to sue the business, because they can't sue you personally. Unless they can come up with some kind of case that they can bring to the judge to say, hey, no, judge.
Yeah, that was
Okay?
So if the business doesn't have enough money and they get sued, what happens then if they can't find something like that? They're out of luck.
They'll be out of luck. See, they went for a deep pocket. They couldn't sue Miss Tompkins. Obviously, the business, for some reason, they can't. They could have sued the business. For some reason, they wanted to sue Mr. Deckman personally. I wonder why. Because he has money.
That was really not right.
But his kids were safe.
Which
They
part?
didn't pay rent or anything. They could have at least recognized.
This is why I want to bring this to your attention, because it's these types of situations where people don't pay any money, but it turns out that they end up having to pay a lot of money because of a mistake that they made. He should have paid them, because it's not that much money to do any. You go to small claims court and pay $50 and do an eviction. Okay, he's an attorney. It wouldn't have cost him much money at all.
Right.
So, unfortunate. Okay, are there any other questions? Yes, sir.
What happens when a person sues a company, but the sole proprietor or whoever it is claims bankruptcy and doesn't pay, but then they continue on with their business and they're making profit on that. Because there's a thing that's going on.
Well,
I know
okay.
a person that's going
Okay, well, if you file the bankruptcy, you just want to make sure that the debt that's owed in the bankruptcy is discharged. The bankruptcy will discharge, that's the whole point of filing the bankruptcy, so that you can have a discharge of those debts. If that particular debt is not included in the discharge, then that debt will still be owing. Not all debts are discharged in bankruptcy.
But isn't that like a crooked way that you could go about going with bankruptcy if the person continues to do business and stuff like that? Like, then you can hire like a collection.
Well, that's what I'm saying. Yes, you can, unless that debt has been discharged. Once the bankruptcy judge discharges that particular debt, that's it.
Okay.
That person can continue on, moving up right along.
Is that what happens a lot?
It does.
Okay.
Yes, it does. Yes. Yeah. That's why people file bankruptcy. Yeah. Yeah. Are there any, and we're going to get to bankruptcy next. Are there any other questions? Very good questions. I love questions. Okay, well, please, ma'am and sir. I was hoping that somebody was going to tell me about that source of law. Nobody did. We talked about
Statutory.
Okay.
Statutory law?
Okay, and thank you. Law that is made up by what did you say? Say it again. A governmental. Remember we talked about that?
Sure.
Oh, you said a long time ago. Well, that was the whole point. I have to build a foundation so that we can come to this moment. Okay, thank you. And please hand in your exit tickets before you leave. I want to make sure that you all know that another special activity is coming up. And